Okay, right. Marta, we're gonna speed up a bit, I suggest, because
The Italian
I
spoke too long.
think, you know, it would be stretching the patience if we eat into the coffee break. I mean, that's where the joking stops. Right. I want to speak about something which I think is normally very accessible, because it's basically what we call procurement procedures or methods. It's something I have to admit is very legal, but it is something that I think everybody should be at some stage aware of, even if this doesn't really feed directly into your PhD thesis, although you can't know this at this stage. Yeah. So we're looking at procurement procedures, also sometimes called methods of procurement. Now, that one? No. To go? No, this one? No, it's not moving. It's not moving. And the first slide, that's too much on it. Okay. Because what we are looking at here is simply a sequence of actions, mostly actions taken by the contracting authority, but also of the bidders, starting with the actual publication of the contract and ending with the conclusion or making of the contract. Yeah? This can be strictly regulated with formal requirements to be fulfilled, and also time limits. Time limits are a clear feature here as well. Some procedures have basically no discretion of the contracting authority. The contracting authority almost works like an algorithm. Yeah, and some involve a lot of discretion of the contracting authority. Yeah? There can be a complete ban on negotiations of the public contracting authority and the private sector actually talking about the contract, a complete ban on that, or that can be at the very heart of the procedure. Yeah? So in some procedures, you don't want contracting authority and bidder to talk about the contract. In some procedures, that's exactly what you want. Yeah? That's all something that they that features in procedures. There's always, at least under the EU rules, a form of publication. You always check the qualification of the bidders, which is something which we will do in the next session at greater length. There, you're not actually looking at the contract at all, you're just looking at the bidders. Why? Well, because, for example, you want to get rid of complete idiots. You don't want to have a contract with an idiot. You don't want to have a contract with somebody who has never done a contract like this before. You don't want to have a contract with somebody who has been very bad in other contracts, who hasn't got the qualifications that you need, who is not meeting legal requirements for you to participate at all.
Someone that lies.
Someone that lies, doesn't pay taxes, doesn't pay social contributions. We're already getting into sustainability here. Reviewability. So at least in the context of the EU, all this should always be possible to review, especially in the court of law. And conclusion is always there as the ending point. Yeah? Now, if I look at, all right. No. Is this working? Yeah. Now, don't be shocked at this here. I'm just trying, you know, obviously I have this slide to actually shock you, but then I want to take the edge off again. You don't need to know all this. I'm just giving you a bit, this is the list of procedures in the ancestral model law. Something I didn't say about the ancestral model law, that the ancestral model law is also designed as a bit of a menu, meaning it offers you all these procedures, but it doesn't suggest that when you draft your procurement law, your own national procurement law, you should have all of them. You should have a selection, also because perhaps some of them are quite similar and are only different in small nuances, so that you really should say, do I take this one that allows negotiation or do I take the other one? One that I'm just showing you here, one of them is, yes, the request for quotations, yeah, near the bottom. Yeah, that's a nice one. Actually, I would tell you, when you get a plumber in, or when you have somebody doing your garden, or when you want somebody to paint, your living room or something, you should actually use this technique as well. All it wants is that the contracting officer gets 2 or 3 quotes for the work to be done. Okay, so, and you should, if you have a bigger work, something like this, like costs €1,000, yeah, something bigger, you should not just go, I know we all do it. We all do it. Contracting officers would love to do it as well, but you shouldn't always go to the same one. You should ask the one that did your last painting for a quote, and then 1 or 2 others perhaps that come through recommendations from your sister or from your best friend or from a colleague, yeah? So you get 3 quotations, and well, you will then have differences in price and in conditions, or you get exactly the same offer from 3 different ones, then you can't do anything here. But basically, this is already a very simple procedure we could all use, and for small contracts, it's suggested the UNCITRAL allows for this. So if a small, let's say, new office equipment, new printing paper or something is bought for a local authority, then this could be a possible procedure. Yeah. Perhaps let me use the bottom one as well. Single source, meaning I don't have competition. I buy this from one particular provider. You will tell us later why you might want to do that, or you might not want to do that. The classical one is the top one.
I just wanted to add what I think also this is helpful is because depending on which jurisdiction you'll be using in your project, the language will be different.
Yes.
So this is for also you not to get scared, because every time that you would look in any of the European countries, the language will reminiscent what is the language used in the directives. But the moment that you may want to look outside of EU, you will look into some Asian countries, African countries. They often will follow the wording of the UNCITRAL model law. So the name of the procedures will differ depending into which sources you would look like. And the main 2 probably that give you an indication what it means would be the UNCITRAL model law and the directive.
Yes. Yeah. Okay. That's, for example, when I look at the first 2 procedures that are listed there would be a classic example for that matter, because very often the UNCITRAL model law only speaks about tendering. But tendering is basically, should perhaps be referred to as open tendering. In the EU, we call that the open procedure. And it is exactly what it says on the tin. It means that the contract notice, yeah, everybody who sees the contract notice and is interested to bid for this contract can bid for this contract with full tender documentation, yeah, straight away on the basis of the contract notice. Okay. Many of the other procedures, restricted, 2-stage, etc., they are worried about you getting too many bids. Okay. Or too many, and especially too many bids of people who are perhaps not qualified anyway, or who are completely unreliable, or who might not be able, who might go bankrupt before they can actually perform the contract. It's a big problem, by the way. Yeah. That's why perhaps so many contracting officers love to work with the same people all the time. I mean, you survived for 100 years, I would like to work with you, not with this startup bidder who might actually go bankrupt next year. Yeah. So, and that is already a problem.
And that also goes back to the efficiency point, because if you also get too many bids, which is in general not really a problem in public procurement as a sideline, but theoretically, you also don't want to get too many bids, because that also will cost to evaluate them, right? You need to invest in resources of contracting authorities, representatives, public servants to go through them. So that's also as a balance to it.
You receive 100 bids on a relatively minor contract, you have a problem. Who's going to look through all these bids? Because they're procedural requirement. Yeah, you can't just say, okay, Martha, let's just take this bunch. We've got too many and put them in the bin.
You just throw out and what
Yeah.
lands on the desk wins.
You know, I've got a holiday set up. You know, I can't really do this. I want to go away. I'm going to go have a dinner with friends this evening. I'm not going to work through 100. So let's just randomly, can't do that. Of course you can't. If you grab the bidders, once you receive them and they're all timely, you have to work through all of them. Yeah. Okay, let's then start to play with these a bit. Yeah, and I've got, first of all, yeah, these are the ones that you have in the directives. The EU directive 2014-24, which is the public sector directive, which is kind of like the mother directive, you could say, the one that regulates procurement of the public sector. Open procedure, restricted procedure, and then various negotiated procedures, competitive procedure with negotiation, and competitive dialogue. You're asking what's the difference between the two? I say I'm a professor of law on this, but I don't really know. It's not so particularly clear what the difference is. Perhaps they just wanted to have, oh, we've got all these procedures, and actually two of them are rather similar. Innovation partnerships, don't even go there.
It's not really a procedure. Let's start with that.
See, starting right here. Yeah, it's not really a procedure. Then we've got the negotiated procedure without prior publication. Yeah, which is the smelly one, the stinky one. The one which without publication means without competition normally, and this is not really what you want. And then we've got, and we're not going to deal with this now, before coffee, you will be glad to hear, forms of electronic procurement that have introduced various possibilities to actually speed up things. So we've got framework agreements, dynamic purchasing systems, electronic auctions, and electronic catalogs. I'm not going to speak about that, but basically that is we're putting everything on the computer, speeds up things. And we were not going to deal with this now. Okay, you do that? Yeah. Let's look at simple competitive procedures, I call them. So the open procedure and the restricted procedure. Everybody's got the open procedure, I think. Some form of open procedure, yeah? Long time I went to a place in China called Shenzhen. It's just north of Hong Kong. And I was there with a tender board and gave a presentation, and they were very surprised that you would have anything other than the open procedure. Anything other than the open procedure is already completely prone to discretion, therefore corruption, and must not be allowed. So everything goes along the open procedure, nothing else, always just the open procedure. Yeah. What happens here is you basically advertise the contract. In the EU, you do that on the tender portal of the EU. You then receive, within 35 days normally, full bids with everything that you need from the bidders who are interested, who saw the advert and want to participate. So it's open, meaning everybody can participate. You then check the qualification and probably get rid of one or two of them at this stage. And then, within a certain time limit, you award the contract. So you say, you are going to get the contract. And then you have to wait for 10 days before you can actually conclude, make the contract. Why is that? It's all about litigation. Because within these 10 days, everybody who's not happy with this award, meaning one of the others that bid for the contract and think that something dodgy went on or something was not done according to the laws, has then the opportunity to bring this to court. Okay, so this is the reason, because we had this in many systems before, that this was happening during the same exact second. There were procurement laws that basically, with the award, the contract was automatically concluded with the bidder in the same logical second, which basically means you can't really litigate, can you? Because it's already done. The contract is concluded. So that was changed through the case law. Let's look at the difference to the restricted procedure. Here you start the same way. You advertise a contract notice, and then within 30 days, bidders who see your contract notice make a request to participate, not full tender documentation, just I would like to be considered with qualification information, and that's me. Yeah, I would like to be considered for this, and here this is me. I paid my taxes, etc. Check qualification, and then you make a selection on the basis of the selection criteria, and you then invite 5 of those who have put in a request to participate to provide you with full tenders. So only now you get what in the open procedure you get much earlier on. Yeah, but you only, 5 or minimum of 5, you might want more, but this is how it works, minimum of 5. And now you receive full bids from them, probably. Perhaps one of them dropped out or got bankrupt in the meantime. Can all happen. Then you award the contract, and again, conclusion of the contract. You? What are the, let's look at the open procedure. What are the advantages? Very transparent. Yeah. Competition couldn't be bigger because everybody who sees it can, in principle, participate. You're not pre-selected or anything. Everything goes straight to bid. It's very inclusive. It probably works. That's why, remember the little anecdote from Shenzhen in China. You think it's best for probity. Probity is the opposite to corruption. It's when there's no corruption. So for probity, the open procedure is best. Even what they did is that the bids were in envelopes, and the envelopes were opened, and there would be, television would be there to see you while you open the envelopes, and then show you this is the lowest bid, so that there was actually no discretion at all. Yeah, so that would be really pushing it to the limits. It's very fair, and ultimately quite simple. I think we all understood basically how an open procedure works. Yeah. Disadvantages, and that's the biggest one. It means that you must be able, at the very beginning of the contract, to describe exactly what it is you want to buy. Yeah? So if you're buying printing paper, if you're buying perhaps simple office furniture, that won't be a problem. Yeah? So you can finalize specifications. In the specifications, you describe exactly what it is you want to buy. If you can't do that, then this procedure is not for you. Because everything from the very beginning is based on these finalized specifications, on this precise description of what it is you want to buy. If you can't really describe exactly what it is you want to buy, you cannot use this procedure. There is no room for market input, meaning intelligence, meaning that perhaps the market knows something about how you can best achieve your objectives. Yeah? So I wouldn't really use this to buy the army's next battle tank, because that would basically mean that the Ministry of Defense officials, civil servants, describe exactly what the features of this battle tank, and the defense industry has no input. Plain stupid. They know better what can be done. They have the people that the Ministry of Defense does not have. Yeah? So the more complicated it gets, the less adequate the open procedure is. It's inflexible. You start the whole thing and you really need to have, basically probably best put this these days into an app on your phone. Oh, today, boom, now we have to do this and we have to publish this. The administrative burden can be enormous when you get more bids than you can handle, although this is not really such a huge problem in practice. Perhaps it's a bit slow, and perhaps it's a bit too simple for many procurements.
Well, this is also one of those procedures that we start to play around with the notion that maybe artificial intelligence can do this procedure, because it does not require much creativity, it does not require much attention to the detail is very much checking boxes, this sort of very old school administrative approach to doing things.
Yes.
But then the very good example, you mentioned office supplies. What else comes to your mind as a really good example for when open procedure actually is all that you need?
I always knew the example of ammunitions for the armed forces.
Because Martin also sits in defense procurement, FYI, if you didn't get that part yet.
And the specific directive on defense does not allow the open procedure. So although it is extremely adequate for ammunitions, it's not allowed under EU law.
Yes. Yes. So and now if we sort of turn to the opposite side of it, I came to procurement very much from commercial settings. So when I was doing my PhD, I looked into the most complex type of procurement. So this type of public-private partnerships that go around 30, 40 years. And information from a market very often that you're going to get is this is not how it works in commercial setting. You need to talk to people who you do business with. You need to clarify things. You need to have some form of interaction. So this type of simple procedure that we just mentioned are quite problematic the moment that you start to introduce a certain level of complexity. So when we're talking about complex procurement procedures, and those are just the ones that were mentioned in the earlier slides of Martin's, but just to categorize them in 3 groups, and they following from the directive. If you have a need for negotiation, so this need of communicating with your suppliers or potential suppliers, we often go to competitive procedures with negotiation, because that ultimately means that you have idea what you want to buy, but you may want to have some type of interaction, if that is pre-procedural with a technical dialogue. Then during the negotiation, during the procedures, you want to hear what the professionals in the field knows and how that can make your procurement better, your contract better. And that one is, to some extent, quite interesting to look historically through the development, because we moved very much from this assumption that everything that has to do with negotiation is prohibited and is evil. And particularly, Great Britain was advocating for many years within the EU that this is just unreasonable. We need to allow a certain interaction within the suppliers. But for those countries in which probity is of an issue, so those countries that really struggle with corruptive behavior, this is a festering ground for troubles, right? When you let them talk. So that's where some type of balance over the years we were trying to strike, and why before 2014 directives, this negotiations with competition was already seen as an exceptional procedure. This slightly changed. So currently, this is a type of more standardized procedure, but you need to have a reasons, and I'm going to get to that in a second, to use this. But in general, you go to the market, you do the same things that Martin mentioned, you inform the market what you want to do, but you have a specific time slot in which you can actually, in a very structural way, communicate with your potential suppliers. And then we have a special procedures, the competitive dialogue innovation partnership. Innovation partnership, as I mentioned, as I digress during Martin's presentation, that's not a procedure. It's a partnership. It's a very bizarre formulation if you ever go through and read through it, because it tells you what and how you need to structure your interaction with your supplier after you award contracts. It's not a procedure. It tells you that you need to have KPIs. It tells you that there are different stages of your contractual relationship. And competitive dialogue is also a type of competitive procedure when the negotiation, but specifically designed when you do not know ultimately to a certain extent what you want to buy. So the classic example is when you're saying, well, you need to connect point A with point B, but you don't know if the better solution is to build a bridge, to build a tunnel, or maybe have a ferry service. Because there might be plenty of consideration that you need to have in mind. Things like environmental impacts. Maybe there are some particular frogs that are protected in the region, and maybe sort of the rocks formation is very difficult. So this sort of elements that require innovative conversation are within competitive dialogue. As a side of digression, my personal opinion is that Commission just didn't want to admit that they were at fault of introducing competitive dialogue as a procedure that's useless, that we never needed. That's why we have two of them, because you can do exactly the same thing with competitive procedures, with negotiation and competitive dialogue. And then we have exceptional procedure, the one that Martin, as a lover of competition and transparency, dislikes the most, which is the negotiated procedure without pure publication. And that is in general perceived that something very special, very unique situation needs to occur for you to be allowed to go for that procedure, because all these objective principles that Martin and Roberto mentioned to you at the beginning of today, well, they are gone in many ways. You just go and you contract the same way as you contract as a private individual. If that's as a customer or a private company, you just call someone and you make a contract with them. You can do that. But at the same time, if last 2 years showed anything, it showed that situations of urgency, such as COVID, require particularly urgent contracting on governmental side. So that procedure came in handy. Of course, there is plenty of example how it has been abused in the process, but that's a sideline. Where we are on time. Okay, so the reason why I also include here a specifically wording of the directive, because also for the non-lawyers, I think it's very important for you to get just familiar what this is about. And I very much would encourage you at the beginning of your PhD, actually print out whatever the legal act is that you'll be working with, have it in a printed version. Use that text. Mine, after 11 years, looked like someone chewed that corners of it, but I cannot work with any other version of that. So it's very helpful. It sort of helps you go through it. And this Article 26 specifically, so what happened with the newest directive, as I mentioned, there was this opening of saying, okay, yeah, we need some negotiations, but it cannot be unstructured and it cannot be unlimited. It needs to happen under very specific circumstances. And ultimately, this Article 26 points out under which specific circumstances you are allowed to use, if that is this competitive dialogue procedure for innovation or competitive procedure with negotiation. To simplify it from lawyerish to normal, so to speak, if your contract is very complex due to technical reasons, due to financial reasons, if there is a need for some type of innovation that you're trying to transfer through the contract, if you're not able in a very precise manner finalize your specification, those are all reasons that are sufficient for you to be able to use those procedures. Or if you actually in the first place try to run an open or restricted procedure, so the ones that have been mentioned, and you only received what we refer to as irregular or unacceptable offers. That means that all the offers were submitted after the deadline, or it was not compliant with the requirements, or it was way over budget of contracting authority. So you need to dismiss them. And if you try already Martin's way and it didn't work out, then you kind of allowed to use the more two-stage procedures, what we refer to them, that have a level of negotiation. So how they look on the timeline, as mentioned, you have a contract notice that is published. So you inform the market what it is that you want to buy. Then you provide a minimum days for the potential companies that want to contract with you to express their interest. And there are timelines for that. Usually it's 30 days. If there's a matter of urgency, it's 15. Then you have, again, a time limit for submission of initial tender. So you submit a first version of your tender, and that first version of the tender often will provide a basis for structuring of your negotiations. So in other words, we all know what we're talking about, and there are some aspects that can be negotiated. What is also very important, though, in that contract notice at the very beginning of the process, you need to indicate so-called minimum requirements. And those minimum requirements are the type of elements of your procurement that there's no way we're going to negotiate. They stand. This is the sort of benchmark. It's not scalable. You can perform better, but it's yes or no, or you're in or you're out. So you need to fulfill those minimum requirements, and those will not be negotiated during the negotiation time. That process of negotiation can also be structured in several consecutive stages. So you can do it 2-3 times around. And after each of the round, if you informed your market in the contract notice at the very beginning, you can systematically delimit the amount of suppliers, the bidders that you're negotiating. So let's say you started with 4. Then after first round, you're sure that one of them is a no-go. So then you go into next stage with maybe 3. And then you maybe let those 3 submit their final tender. And then you will make the award decision and you conclude the contract. The reason why I put that timeline, because it's also important to understand that it's a very specifically designed time slot, so to speak, where you can do this negotiation. So as you see, after you conclude a contract, it's not that now you can also renegotiate things. So it's just in that specific green line where you can do that, right? And that's important to have in line, because if you suddenly would be able to renegotiate terms of the procurement after contract was awarded, I hope that you all can see that it would be pointless to have a procurement in the first place, right? And then the unfamous negotiated procedure without publication. And you very clearly see that this is much less structured what I showed you a second ago. You pick up a phone, you call someone that, for example, you had a contract 5 years ago, the price was good, quality was good. You kind of really need to use them due to urgency, let's say in COVID times. You conclude the contract, you can negotiate it all the way through. But because there is this most extensive amount of discretion of contracting authority, there's no transparency, you don't publish anything. This is one of those procedures that also the justification for usage of it are interpreted very restrictively. So everyone will always be very strict about, did you really needed to use that procedure? Maybe not. Maybe you could have done something else. And there is a whole list which I didn't copy paste it from the article on negotiated procedures without prior notice, but I just wanted to give you an indication of what are some of the reasons why you may need to use it. So again, we got open restricted procedures, or there was no request, so your tender was just very unpopular, no one submitted a bid. Or again, you received a tender that was irrelevant, not fulfilling your requirements. But then there is a whole set of additional reasons. Maybe you need to buy something that is very unique in a nature, and there's only one specific supplier that can provide this type of work, service, or goods. It also can be that there is a lack of competition due to technical reasons, or there is something connected with exclusive rights. So someone holds, let's say, particular IP that you really need a solution with usage of that IP. The unforeseeable circumstances over the last 2 years, as I mentioned earlier on, really gain a lot of attention because COVID was a very prevalent example of what unforeseen circumstances are. And there is a tons of literature and research right now conducted on also, well, we right now still within COVID times, right? 2 years later on. Is it still unforeseeable circumstances for me to conclude today a procurement with usage of this procedure 2 years in under COVID? Or at this point we can say, well, we've been with this a while. Probably it will be a little bit difficult, right? The jury, of course, is out. There's be plenty, I think, still of cases and litigation in this area. And then you have some other additional examples under which circumstances you can use it. I won't be reading through them. You have them all within the directive. That's not a problem. What I would want to tie this specific session very slightly to the overarching aspect of sustainability within public procurement. is to reflect on usage of this negotiated procedure without publication. And that the question is, can sustainability concerns justify the absence of competition for award of the contract? In other words, can sustainability be your reason why you're saying that you did not go to competition or not? And that has been tested actually many years ago within the case Commission versus Germany. That ultimately what happened within that case was that German contracting authority went directly and contracted with specific supplier. They contracted a disposal of bio waste and green waste, so it was within the waste collection. And their argument very much was, and this is a little bit complicated case in context that it brings the procurement issue, but it also brings the EU law on waste collection to clash. Because EU waste law pretty much says that you need to treat the waste the closest to the place that you gather the waste. Everyone with me so far? So where you gather the waste, you pretty much should straight away treat it because also of environmental consideration, amongst others. So the Germans said, well, there's only one plant, the closest to us, to our municipality. So we just contracted with them because that from environmental reason means there is a shorter time of traveling for this waste. And what happened then within this case, it of course has been challenged because there was no competition. And ultimately the court pointed out that the technical reason that relates to protection of environment may be considered when you're assessing to who you'll be awarding the contract. So when you got the many offers, but it's not sufficient reasoning to absolutely disregard procurement rules and just go private contracting. So this is very, I think, important in the context of our conversation, because it ultimately says you cannot say, because it will be very easy, right? I need to buy something, particularly right now when we're discussing the issues of CO2 emission and climate change. It would be a very easy argument to say, well, I buy from Martin because Martin's warehouse is the closest to my municipality of Copenhagen, so we're going to save all the CO2 on transportation. I don't need to have an open bidding process and have companies from Sweden and Germany and other countries bidding. I will just get Martin, my neighbor. And that is very clearly stated by the court. You cannot use it as an excuse to absolutely disregard the procurement relationship.
And of course, when that happens, if you have that attitude, I will milk it to breaking point. Yeah, I'll be very expensive and I'll be cheeky and I will not take her seriously. I will, basically prioritize other customers where I have to compete. The quality will be lousy.
The price will go up.
It would really, I'm basically going to be absolutely awful. And this is what needs to be considered there as well.
Highlighted, right? So it's important in context of this procedure to also have that in mind. Anything to add?
Has everybody understood the point about IP, intellectual property? Yeah. Basically, if somebody has a patent for the product that you want to buy, there's no point in having a competition because it would be illegal for anybody else to be able to produce this. Yeah. And perhaps when it comes to all the reasons that you see about the negotiations without competition, this last procedure, the requirements, I think there are a couple of requirements. So, for example, I think you have to publish that you did use the procedure, and then your decision to use that procedure can be challenged. Yeah, so there are, it's just very little, an absolute minimum of requirements. And what I find important, and I'm normally, in the course I say this procedure really stinks from the perspective of trying to have a competitive procedure, have a competitive environment, transparency, and so on. what I want to link it to is perhaps what I will do after lunch. It's about coverage. That's about the question whether the whole procurement law system actually applies at all. And I think this question of does a procedure come under the negotiated procedure without prior call for tender is very close to not being covered at all. Yeah, so and it needs to be taken into account when you look at the question of should the procurement system not apply at all, or should I use single source procurement, as you could also call it. Yeah, so these are very, very, very keen, and then it's very nuanced to decide, can I address the situation I'm dealing with here, for example, a patent, through single source, or is the situation that I'm having, perhaps in the context of COVID, so severe that I need to get completely out of the procurement system and do this kind of in a free way that is no longer bound by procurement law, and then there's no litigation, and there's, yeah. So all this does is that the procurement system, through different procedures, tries to take different situations and constellations and markets into account to provide the procurement officer with the right procedure.
Can I just, because we have 2 minutes, can I just for a second be a devil's advocate and entertain me for a second, Martin? What is the reason, though, if we think about single source, and if I come from sort of hardcore private commercial contract law, my argument would be, but you can just write a contract in the way in which you're saying, well, the prices needs to be, let's say, every 6 months benchmarked to the price of the market, and you need to give me the pre-agreed 15% discount. The quality checks are there, contractual clauses giving fees for some sort of divergence from original agreement would be there. So why this is thinking procedure? If you could do it, couldn't you secure your best interest through a contract?
Absolutely, but I don't want that sort of thing in this network. Yeah, we are dealing with procurement. Yeah, because you are absolutely right.
I think this is just something, you know, sometimes that I think it's also important for all of you to consider. Because, for example, if you go really outside of Europe, if you go to US, anywhere outside of Washington, or you go to Canada or Australia, as an academic in procurement, they will say, procurement what? Say, it's contract law. And also what there is an argument about efficiency, resources, holding a 6 months procurement procedure with 5 candidates and negotiating, that takes time and money. If I can just contract with someone, then straight away I know that are good and solid, I'm going to save money. That would be efficient. So there is the reason very consciously, and the very end of this, why I'm bringing that up, because I also want you to think a little bit broader, the contextual reason for it. A lot has to do with European structure, right? A lot has to do with the different national structures. And you will have that context when you will research these different elements. We, of course, are very focused on procurement, and procurement is the most fascinating and important. But in case if you will come across colleagues that don't see that, this is also, I think, important to have in mind that very often when you talk about contract law, people will say, well, you can do kind of similar stuff if you just do a good contract.
Okay, and now we're all going to benefit from the single source contract from the coffee place.
Yes. Yes. Hopefully a very good coffee.
Yeah.